you're in a situation where you have the discretion to put it in your trust account or your business account because the client has not mandated that you keep it in the trust account. That's the only time you have to keep it in the trust account if the client says, I want you to hold my money in your trust account. But if they don't, you have a discretion to hold in your trust account, hold in your business account. Now, if you put in your trust account, you add a lot of responsibility on yourself, handling it as trust funds when you may not want to put that on yourself. All right. I'd rather, if the client hasn't told me to keep it in my trust account, when I earn my fees, I'd like to be able to take my fees from the retainer and then tell the client I took the fees. And, if I need them to replenish the retainer under our agreement, I'll ask for it. Now, if the client disputes me, I know I'm not looking at being charged with knowing misappropriation. I'm in a fee dispute. The issue, so I always recommend, if you have the option, put it in a business account. And I say a business account, not your business account, because I want to add this. One of the problems is a lot of attorneys only have one business account, although the rule allows you to have as many as you want or need. Okay. So let's say you have a general operating business account where your fees go in, you're paying your staff, you're paying yourself, you're keeping your funds in there to handle the office expenses and the like. But you do not want to put a client's retainer in there because you don't want to run the risk of impacting it before you feel that the fees were earned. Now, but you also don't want to put in the trust account because you don't want to add that extra burden. The rule allows you to open up a second business account. You can call it retainer fee account. And you can put the monies in that business account, treat it as if it's trust funds in terms of your strictness in how you handle it, but you don't have the sword of a trust fund hanging over your head if you make a mistake or if you disperse fees to yourself and the client later says they dispute it.
John, let me give an example of where this is a good idea. Let's say that I have a big case in Willingboro Municipal Court, okay? Big case. And I charge the client $100,000, okay? That's the legal fee. And the client plunks that money down. That's an enormously big fee. I would not put that in my general business account. I would put that in a separate account, business account, just related for this client, because if the client comes back a week later and says, oh, I found a better lawyer than you, I changed my mind, can I have my money back? Before you've done any substantial work on the file, you're going to have the money there and it'll be available to refund to your client. So that's the type of situation that would come up where I would have a designated business account for that type of client.